One of the other things he said is he kind of volunteered this information, and I wrote down a quote again that last time I shot it, the defendant says, last time I shot this pistol, I could really hardly shoot it because of my arthritis. So first of all, you mentioned the fact that no guns, no weapons are to be allowed in the theater where he was. Why did he have a gun in the first place? But second of all, do you think that anything's going to be made of the fact that he admits he had arthritis, could barely shoot it, and yet that's what he did on that day in question?
Yeah, Ashley, I took a note of that comment as well, because if you're the defense, you're going to do your best to paint this gentleman as an older man who's very frail, who has lost that kind of fighting spirit that he did back in the days when he was in the department, that he's got all of these disabilities, the arthritis in his hands and his knees. And one point that he did make that I think if I were the defense, I would highlight is that he felt he had no other options. He felt that this person was going to beat him up and he couldn't physically respond to that. And that might convince a jury that it would have been reasonable for him to use some other means to defend himself. But still, I don't think we've reached that level of fear of life. It's not fear of physical harm. It's not fear of physical harm of his wife. It's fear of the taking of his life. And they're really going to have to play up the fact that he's this older, kind of frail man, that perhaps he would have been physically injured to the point of death if this turned into a physical altercation. But again, I think that's a hard road for them to go down.
I think I would anticipate them using that video because, again, the first time that I watched the video, Josh, and saw it, you can see the gentleman coming towards the man, the defendant, sitting in his seat. He is 71 years old. He does just testify about the fact he must have had arthritis. And if you see someone coming towards him, let's watch this together, Josh, because I do feel like this is going to be key in the defense's argument. I'm not saying who's going to prevail. I don't know. A jury gets to decide. But key in the argument, I think, is when he's sitting there and the now we know victim gets kind of in his face, comes towards him right there in the chair. I do think they're going to use that to say he feared his life because, look, he came at him. What are your thoughts before we go to another story to talk about?
Sure. Yes, I agree with you. I think if you're the defense, you're going to have to highlight the fact that he remained in his chair, that he may have started this altercation in the sense that he asked the guy to put his phone away and went to the management and complained about him, but he never physically brought things up another notch. He remained in his seat. If you're to the defense, I think that's all you really have got to work with there, is that he remained in his seat and responded in the only kind of reasonable way that he felt that he could as a 70-year-old man with the disabilities that he has.
And somebody pointed out, and I can't remember if it was you, that the theater was empty. Can I just tell you, I feel like when I've gone to the movies and nobody's really in there and we sit down, inevitably someone sits right behind us or right in front of us, and you have the entire movie theater empty. And yet again, I think there must be some underlying human action that always happens, because I've gotten up and moved before simply to give space, and it makes me feel more comfortable. But to your point, he did say, yeah, I wouldn't do it again. I would have just moved. But that's looking back, hindsight. This jury has to make a decision based on the facts presented to the jury and the law that's going to be given to them if this is second-degree murder, or in the alternative, if they believe his stand-the-ground defense is valid.